Good morning, everybody, and welcome to today's Open to Export webinar about the new Incoterms 2020 rule changes and what exporters need to know about them. My name is William Barnes-Graham, and I'm the Senior Content Editor at the Institute of Export and International Trade. Open to Export is a free online service helping small businesses get ready to sell overseas through our step-by-step articles and guides, regular webinars, our Export Action Plan tool, and our quarterly competitions. You can find out about all of these on our website at www.opentoexport.com. Open to Export is powered by the Institute of Export and International Trade, the UK's professional membership body for traders. Endorsed by the World Trade Organization and the International Chamber of Commerce as a small business champion, we offer a unique range of individual and business membership benefits, education and training, catering for beginners through to master's degrees, and an always exciting and prestigious program of events celebrating UK businesses' exporting achievements. We will be running a live Q&A later in the session, and you can ask questions at any point using the question box on the control panel to the right-hand side of your screen. The general principle here is that we'll only ask questions that are relevant to the broader audience, so we won't be able to go into company specifics as such, but if you do have specific questions, we can refer you to our technical helpline afterwards. For now, though, it is my pleasure to welcome two fantastic speakers. In a moment, we'll be hearing from Corinne Nabavi, one of the Institute's trainers for the ICC licensed one-day training courses about Incoterms. But first of all, we're delighted to welcome Charles Debattista from 36 Stone Chambers, who was involved in the drawing up of the new terms. So Charles, over to you.
Hello, good morning, everybody. My brief with Incoterms 2020 was that I acted as ICC special advisor for this version of the rules, having chaired the drafting group for Incoterms 2000 and again the drafting group for Incoterms 2010. This time my job was to oversee the drafting process and basically to hold the ring when there were sort of difficulties or controversies between members of the drafting group. We hope that we've ended up with a draft, with a version, I should say, which is clearer than its predecessors. And what I've been requested to do in this morning's webinar is to talk briefly about what Incoterms do and do not do, to talk briefly about the drafting process, but then I suppose most importantly to highlight the main changes which 2020 have affected to the 2010 version. Now, I know that many of you in the audience are well familiar with Incoterms, the international commercial terms of the International Chamber of Commerce. But for those of us who perhaps come to this from a relatively new perspective, I'd like to start by explaining what Incoterms do not do, and then briefly by explaining what Incoterms do do. So Incoterms are a set of 11 different terms. The most commonly used ones are CIF or FCA. So these letters will mean something to many of you. They're basically divided into 11 rules, and then within each of the 11 rules you have 10 promises on the part of the seller, called the A articles, and 10 promises or obligations on the part of the buyer, called the B articles. Let me start off by saying what Incoterms do not do. They're not a contract. They don't apply mandatorily. They do not provide you with the answer to the question, what law applies to the contract and where do we take our disputes if there is a dispute. They do not deal with remedies. They do not tell you what the damages recoverable are in case of breach. They do not tell you who needs to pay how much and when and how. And finally, perhaps most surprisingly, they do not tell you who owns the goods at whatever stage. Now, having listed like that those 5 fairly important things which Incoterms do not do, people might be forgiven for thinking, then what on earth do they do? And what they do is something very, very important. They provide users, traders, international traders in goods and commodities, with a safety net regime, with a basic default position regarding 4 areas: regarding delivery and the very closely associated idea of risk. They give you a safety net regime for the basic responsibilities which the seller owes to the buyer and the buyer owes to the seller, particularly with regard to other contracts which need to be made, so that Incoterms will tell the parties who needs to organize the transport of the goods, who needs to organize the insurance of the goods, who needs to organize the packaging of the goods, who needs to organize the export clearance or import clearance of the goods. And finally, the 4th area, which Incoterms provide guidance on, is that it provides guidance on costs, and I'll come back to costs later, so that someone who's interested in finding out which is the most expensive Incoterm for his use, then can look at the Incoterms, which will tell them who carries what costs in CIF, who carries what costs in FCA, etc. Corinne, I know, will come to more of this in detail, but these 4 pillars, these 4 areas are basically what Incoterms do. Going back to the top of this slide, the important takeaway here is that none of the 11 Incoterms is in and of itself a contract. It is CIF, the CIF Incoterm, does not provide you with the contractual terms. You still need a contract. Incoterms are drafted at a pretty high level of abstraction, so that they can apply as much to a cargo of crude oil worth many, many millions of dollars, shipped in bulk on an ocean-going carrier, but they can equally apply to 1 container of shoes sold by an Italian seller to a German buyer. So the level of abstraction to which the rules are distilled is fairly high. In other words, the rules, the default positions in the rules are stated at a fairly high level of abstraction, as we shall see when we look at some of the rules in detail. What is the history of Incoterms? The history of Incoterms started in 1936. There have been 8 or 9 revisions since then. The reason why the ICC, this was the first big task of the ICC was set up just after the First World War in 1919. And this was its first major task, what we call soft law development. I'll come to soft law in a moment. And the reason why the ICC entered into this field was that terms like CIF, FOB, were around, of course, way before the First World War. Indeed, you can see traces of terms like FOB, C and F, etc., cost and freight, free on board, back in the late 19th century. But the difficulty was that different traders in different countries understood different things by these terms. So the ICC, which had set itself up soon after the First World War as a collection of merchants for peace, or commercial men and women who wanted boundaries to be crossed in a peaceful way rather than a warlike way, thought, well, let's try and draft a set of uniform rules, a set of uniform interpretations for these various terms, CIF, etc. They've been through a number of changes, as I say, over the years. The ICC has sort of settled down now into a fairly regular routine of changing every 10 years. So why change again? There is an argument for saying that we're changing too frequently. The UCP, for example, the relevant ICC rules for letters of credit, are not being changed this year. The Banking Commission has decided not to change them because there seems no need to. The process starts off by asking national committees within the ICC, do you think there is need for a change? And the answer was yes. So coming down to the next slide, we now come to the process. So if we can go to the drafting process. Now, for those of you for whom the International Chamber of Commerce is new, it is organized into national committees. So there are just under 100 national committees around the world. And the work of the ICC is allocated to different commissions. The Incoterms rules are the child or the creature of the Commission for Commercial Law and Practice. And that commission started off by creating a drafting group, an international drafting group. The whole process took about 2.5 years. So we had a drafting group of 8. 5 of these people were lawyers, including myself. 3 were non-lawyers. The 8 came from a wide variety of countries and indeed continents, and from a wide variety of ranges of experience. What we did as a drafting group was we first sent out a very simple questionnaire to national committees. And we asked 2 questions. The first question was, is there anything in Incoterms 2010 which you would like to change? We didn't stop with that question. We'd sort of asked that question back in 2010 and found that we had an enormous number of rather random suggestions. So this time we took the precaution of following that first question up with a second, rather heavier question, which was, if your answer to the first question is yes, how precisely would you change whatever it is you wanted to change? We found this method of sending out a short but demanding questionnaire very fruitful, because it really did make national committees made up of business people in Thailand, in China, in France, etc., made them really think about what it was precisely that they didn't like in the previous versions, or things which they thought were now out of date because practice had changed or new needs had arisen. The International Drafting Group then proceeded to draft several drafts. We drafted the first draft, obviously, about 2 years ago, back in 2016. And each draft, there were 4 drafts in all, would be sent out to national committees for review. We would receive, after a consultation period of anywhere between 6 to 8 weeks, we in Paris would receive line by line comments on these drafts. The Secretariat in Paris, when I say we in Paris, I mean the ICC in Paris. We were, of course, based all in our day jobs all around the world, but a very, very efficient and very helpful Secretariat led by Emily O'Connor in Paris would digest the comments, would present those comments on a line-by-line basis to the drafting group. The drafting group would then meet. We would have email exchanges between us about the various comments. We would then meet generally for 3 to 4 days in different cities, and we would hammer out the subsequent draft, which would then be sent out for national committees. And this process happened 4 times. There were also 2 open meetings. By open, what I mean is that they were open not only to members of the drafting group, but also to members of the ICC from any national committee. We had one in China this year, this time round, and one in London. These were very active meetings where people not concerned with the drafting would come along and speak, if you like, truth to power, insofar as we had any power, and they would, on a face-to-face, looking at the whites of our eyes, say, why have you done this? Why have you done that? In the end, the current version, which was published on the 10th of September by the ICC, this last September, was adopted by the CLP Commission, by the Commercial Law and Practice Commission. The reason I've spent some time describing the drafting process is that it's very easy to run away with the view that Incoterms are a set of rules drafted by lawyers for lawyers. Nothing could be further from the truth. Obviously, because they are legal terms, legal rules, which will be applied by parties, they do need to be couched in fairly tight form so that there is as little, I'm not saying none, but there is as little room for interpretation or different interpretations or misinterpretations as possible. But the actual substance of the rules were not drafted by a committee consisting exclusively of lawyers, and more importantly than that, were tested by vast numbers, literally hundreds of real people, of business people, who were looking at drafts, successive drafts of the rules in different countries. So that's what I wanted to say about the drafting process. Just before I come to the main changes, I should also say that, of course, I did refer to this briefly earlier on. These are not mandatory rules. I used the phrase soft law a moment ago. What I mean by that is that they can only apply by the special incorporation of the rules by parties to a contract of sale. So they don't apply willy-nilly, they don't apply by force of law. They apply if the parties to the sale contract actually have a term in their contract saying, for example, FCA Incoterms 2020 to apply. A question I've been asked since the launch several times is, when we say that they are in effect from the 1st of January of 2020, what precisely do we mean? We mean really very little at all. What we mean is that insofar as any set of rules needs to have a start date, this is the official start date. But because this is not hard law, because it is not a treaty, because it is not a convention, it is a set of voluntary rules. If parties contracting for the sale of goods across international boundaries now in October of 2019 wish to incorporate into their contract Incoterms 2020, then all they need to do is to say FCA Incoterms 2020 to apply. There is nothing in the rules which prevents them from doing that. By the same token, there's nothing stopping parties contracting in 2020, say February of 2020, who are wedded to Incoterms 2010. There's nothing to stop them from incorporating the 2010 rules. So it really does come down to the consent, the will, the agreement of the parties as expressed in their contract. If we go to the next slide now, you'll see that I have, and if we jump very quickly to the next slide after that, you'll see that I've divided up the main changes into two groups. The first group, if we go back one slide, is made up of the main presentational changes. The second group is made up of the main substantive changes. So the presentational changes, I start with the presentational changes because, in a sense, these are the most obvious changes when you compare 2020 to 2010. The first change, which was quite controversial and very heavily discussed by national committees, was that we completely changed the order in which the 10 terms in each Incoterm rule appears in the book. In the book, in previous versions, there was a more or less historical sequential sequence, sort of narrative sequence in the way Incoterms were presented. In training and in our professional practice as lawyers or businessmen advising people on the use of Incoterms, it became very clear that one of the main problems with the use of Incoterms was that traders were using the wrong Incoterm for the wrong transaction. Let me give you an example. Only last week I was advising on a case where something happened to goods which were sold CIF, and something happened to the goods while they were in transit to their destination, and the destination was an English port. I can't remember which port it was. Let's assume that it was CIF Southampton. And while the goods were making their way to Southampton by sea, the goods were damaged. The buyer, an English buyer, was very unhappy with paying for these goods. And the question I was asked was, why do I have to pay for the goods if the goods were never delivered in Southampton because the damages, because the goods were damaged in the meantime? What that question illustrates is that the user, the buyer there, thought that because Southampton was mentioned, that was the point at which risk passed, whereas it is in the nature of CIF that risk passes at the point or port of shipment, not at the point or port of destination. So we thought, well, perhaps it's our fault, perhaps we have not given, in previous versions, sufficient prominence to the idea of delivery and risk. So those go right up to the top of the way we list Incoterms. The second procedural change, presentational change, is that we now list in the book not only the 11 Incoterms in order, but we also provide the users with all of the terms across the 11 which deal, say, with shipping documents, all of the terms of all the 11 which, say, deal with delivery. The reason we published this tool, this what we called horizontal version of the rules, was that this way a user who was particularly concerned, say about cost or say about risk, could compare the 11 Incoterms across that spine, looking simply at risk. We've hyped up the guidance notes, which now become explanatory notes. They're a bit fuller than they used to be. They're a bit more legalese. And the reason for that is that we've asked to provide arbitrators and judges with clearer guidance as to the interpretation of the rules, so that we go behind the black letter of the rules and provide arbitrators and judges trying to apply the rules with a view as to what we had in mind. Finally, we have really tidied up costs. A9, B9 now provide in one fell swoop a list of all of the costs which a CIF or an FCA seller must bear, and all of the costs which a CIF or an FCA buyer must bear. We were alive to the fact that for business people, the bottom line is a very important line, and therefore we wanted to make sure that there were no surprises, that by looking at A9 or B9, you have a complete list of all the costs. If we go quickly now to the second, the second set of changes. 5 sets of changes, 4 of which are particularly important. and because I'm running out of time, I shall do this as quickly as I can. The first substantive change was the most controversial, and that is this. In free carrier named point, otherwise known as FCA, which is an FOB type term, but where the point of shipment is not a port, it is an inland point. If we take England as an example, you would never want to buy FOB Winchester, because Winchester is not a port. If you're choosing FOB, then you would be saying FOB Southampton. If you wanted the risk to pass at an inland point, say in Winchester, then the term you should use is FCA, which means that when the seller hands over the goods to the carrier at a terminal in Winchester, all risk is for the account of the buyer from that point on. So that's the difference between FCA and FOB. FCA is inland point, FOB is ocean port, FCA is Winchester, FOB is Southampton. Now, the difficulty is that we found in our consultations that many FCA sellers still needed a bill of lading. Why? Because if there was a letter of credit lying astride that sale contract, the banks would frequently insist on an ocean bill of lading. But the idea of an ocean bill of lading stating that the goods were shipped in Winchester, all I have to do is to state that for people to realize how silly that is. You cannot ship goods on board in Winchester because there is no port in Winchester. However, we had to square the circle, and we have come up with, in A6B6 of FCA, a device whereby an FCA seller is, in certain circumstances, under an obligation to provide an ocean bill of lading. Levels of insurance. Up to 2010, whether we were talking CIF, cost insurance freight on the maritime field, or CIP, cost and insurance paid to on the multimodal side, the level of insurance which the seller had to provide for the benefit of the buyer was identical. That is to say, London Institute Cargo Clauses C, not the higher London Institute Cargo Clauses A, which is of course more expensive because it is all risks covered. There was a move to change both CIP and CIF to Institute Cargo Clauses A. That move was resisted by the commodity maritime trades, and in the drafting group, in a bout of Solomonic justice, we divided the problem up into two, and we decided to retain the lower level of insurance in the maritime insurance term, that is to say in CIF, so no change there, but with CIP, the level has gone up to A clauses, all risks. I'll skip over C, it's not a very important change. D, in a sense, is not a very important change. We did not change the delivered at terminal term. It is identical to the way it was in 2010, but we've changed the name. It has now become DPU, delivered at place unloaded. The reason for that change is set out in my introduction to Incoterms 2020. Finally, security-related requirements. 2010 was the first version of the rules which was revised after 9/11. So you'll see in 2010 the first entry into Incoterms of who pays for checking, say, containers, and that is not surprising. Excuse me, because after 9/11, of course, the United States, as is well known, introduced many new regulations for incoming cargoes, particularly cargoes contained in containers. Since 9/11, the phenomenon in terrorism not being restricted to the USA, and of course the regulations regarding security-related checking and manifests, etc., becoming more detailed. The text on security-related requirements, who pays for these obligations, have become much more detailed, and in Incoterms 2020, there is far more emphasis on who is under an obligation to provide or to assist in the procurement of these security-related bits of information, and above all, who pays for them. I hope that that quick run through the changes excuse me, provides you with a broad panorama of what it was that we did and how we did it in the revision process for 2020. I should finish by apologizing for my voice and my cough while I was presenting that, but I happen to have been attacked by a seasonal lurgy. But thank you very much indeed for listening.
Great, thank you, Charles. And now to run through some of the practical implications on businesses. Over to you, Corinne from the IRE.
Good morning, everyone. This is Corinne Nabavi, and I'm a trainer with the Institute of Export. Next slide, please. Next slide. So here, so introduction to Incoterms. So the following slides will provide a brief introduction to Incoterms 2020. The rules will explain the set of three-letter trade terms reflecting business-to-business practice. There are 11 Incoterms, 7 for any mode of transport and 4 for sea. And as Charles has mentioned, that they in themselves do not relate to a contract. It's only when they're incorporating a sales contract do they become part of that contract. The Incoterms rules set out the obligations, risks and costs in the delivery of the goods from the sellers to the buyers. Next slide, please. As Charles mentioned, here's some of the history of how the slides have been updated over the years. And up to 1967, they were periodically updated. And again, as Charles mentioned, the reason for doing this initially was that although there were trade terms around during the First World War and before, they weren't consistent in what the meaning of them was. So this is why there was the development of the Incoterms. Next slide, please. From the 1980s up to now, 2000, well, there is current version, which is a 2010. They've been updated every year, 10 years, to take into account changes in the way that the business and community trade. Next slide, please. So, as I've mentioned before, the purpose of Incoterms is to set out the obligations, risks and costs from the buyer to the seller. The obligation is in who arranges for the carriage or insurance of the goods and who obtains the documents, the shipping documents, import or export licenses. Risk is where the seller delivers the goods, so where the risk is transferred from the buyer to the seller. And then there's the costs, again, costs, where are the costs paid up to in the transaction between the goods that are being delivered. And costs and risks are very important because you need to make sure that you use the appropriate Incoterm, as costs and risks can change at different places within the supply of the goods. The Incoterms are covered in a set of 10 articles. The A being the articles which are covered by the buyer, and the B, the obligations by the seller. Next slide, please. And the main changes, some of these Charles has already reviewed, but let's just go through these quickly. So the internal order of the articles have changed, and we have a slide on that later. Delivery and risk have transferred from A obligations to A2 to A3. there's a new horizontal format setting, which is really useful when you're trying to establish which is the best Incoterm to use for your particular contract or your sales contract. The guidance notes have been updated. There's a reordering of the delivery and risk. Charles has already mentioned about the onboard notation and the changes or the potential changes in the clauses, the insurance clauses of C and A. But it must be remembered, these are, you don't have to apply the fully comprehensive clause A. It can be agreed your customer that you can apply the clause C, but that is something that you need to negotiate with your customer. There's more emphasis in the new Incoterms on the use of own means of transport, which is a common process now. And the 3 letters of initials for DAP, delivered at terminal, to delivered, place, unloaded. In essence, they mean exactly the same, but it's just that the place it can be delivered could be somewhere other than a terminal. And security and the costs allocated here are listed in the relevant terms. Next slide, please. Next slide. All right. So here are all the Incoterms listed by the mode of transport. The first 7 being for any mode of transport, and the last 4 being for the sea transport. As you can see, the DBU, which has replaced the DAT. And one point that I need to really point out here, that when you put these Incoterms into the contract, you must be specific in you name the place of delivery. If you just put the 3-letter meaning, X works, FCA, that does not mean anything until you put the named place of either delivery or destination or shipment. So you must be aware to put the whole meaning of the Incoterm in your contract of sale. Next slide, please. Here again, so we've got the Incoterms by their group. We go from X works to DDP. X works is the Incoterm that places the minimum amount of obligation on a seller, whereas DDP places the maximum amount of obligations on the seller. And I would really like to say to everyone that you should use these Incoterms with caution, and I'll go into that in a little bit later on in another slide. But these Incoterms, although frequently used, they do come with risks for the seller. Next slide, please. Next slide. Here we can see from the 2010 Incoterms to the 2020, how the risks, general articles have changed. In this slide, you can see that the only one that has stayed the same are the Articles 1, which have the general obligations still under Article 1. All the other articles have changed where they're located, but this is to bring more prominence and bring some of the costs and that to make sure that they're all in the same place to make it easier to determine the correct Incoterm. Next slide, please. This slide I feel is really important for within a company. I mean, I don't think I can stress the importance of working together to make sure that you have the right Incoterms, whether it be for a purchase or a sale. I've seen many examples in companies where incorrect Incoterms have been used, and it's caused a significant cost to the business in trying to comply with those Incoterms. If the people in procurement don't understand some of the issues of importing goods, then you need to work together to advise them of the issues that you could potentially face. And the same with a sales department. If the sales departments accept an order which you cannot comply with on the terms of delivery, then it makes it extremely difficult for the goods to be shipped within the terms of the contract. And both of these, if you get them wrong, they can be extremely costly to a business. Next slide, please. Here, again, what the Incoterms, they're not a substitute for a contract of sale. You should have a contract of sale in the place. The Incoterms reflect trade practices for all types of goods. So here we've got bulk cargo, containers or pallets. So it's all types of goods. So here we list what they do not cover. And I'm not going to read them all out, just, they're not the specification of goods sold. They can't be sought for, used for breach of contract. And they do not transfer property or title or ownership of the goods sold. Next slide, please. And so again, Incoterms do not deal with the transfer of property. They don't relate to, they're not in themselves a contract of sale. They're only become that when they're incorporated in the sale. And they do not provide the law applicable to the contract. So it's the contract itself that does that. Next slide. What I'll do in the next two slides, I will look at the differences between the two extremes of the Incoterms, Ex Works and DDP. Now I've got here, sales managers love Ex Works Incoterms because the sale is complete when the goods are placed at the buyer's disposal. And again, I'll go into these more detail when we look at the slide. And again, DDP, customers love that because they've got no risk until the goods are delivered to them. But let's go into that in a little bit more detail in the next slide. Next slide. So here, one of the nice things about the new Incoterms 2020, if you look at the top right-hand side, you have this little picture whereby it explains the costs and the risk. And within each Incoterm, it has these pictures which are really visual indication of when costs and risk pass between the buyer and the seller. The blue represents the seller and the orange represents the buyer. And I think they're a really useful visual tool. So if we look here, we've got Ex Works, and again, name, place of delivery is very important. And in this example, we've got the trademark after the Incoterms, but this set of Incoterms 2020 specifies it's not essential that you put the trademark in your Incoterms rule. So if we look at Ex Works, the seller delivers when the goods are placed, not loaded, at the disposal of the buyer at the named place, which might be your factory or your premises. But the seller does not need to load the goods onto a collecting vehicle. And then, one of the issues could be who bears the risk. And you have to consider that if you have a large equipment which may require a forklift, would you really want your customers sending in a driver to use a forklift truck in your factory or your warehouse? So you really need to consider whether Ex Works really works for you. The buyer has to clear the goods for export, but in reality, it is usually the supplier that does that. And if I look into the UK, if I look at the UK, you have to have an EORI number to do an export customs declaration. And it's most likely that the customer does not have that reference number in the UK. If that is the case, then it will be the seller who would have would use their EORI number, and it could put them at issues because the customs declaration will be made in their name and not their buyer's name. You also have to consider that because this sale would be zero rated for VAT purposes, the exporter will require proof of export to substantiate that zero rating of the sale. So there are risks with using Ex Works. If we go to the next slide. So here we look at DDP. So the delivered at place, delivered duty paid. Again, you must specify as much as possible exactly where that destination, where you will be delivered to the goods to. That could be the arrival port, or it could be your customer's premises. So it's when the goods are placed at the disposal of the buyer, cleared for import on the arriving means of transport. And that means that the seller has to pay all the costs and all the duties and taxes in the arriving means of in the arriving countries. But the big issue for the seller, how well versed are they with the customs formalities in the arriving countries? And you have to bear in mind that any delays with the customs clearance in the arriving country could pose significant costs for your business. So, if you're looking to deliver DDP, you should most probably consider DAP or DPU. These may be better Incoterms for you to use, and it could also minimize your costs in the transactions. So these are just a basic look at 2 of the Incoterms of the 11 Incoterms. Next slide, please. So this is just a brief overview. So we provided a brief description on the Incoterms, looked at the 11 Incoterms 3-letter trade term, and reviewed the 2 extreme Incoterms, ex-works and DDP. Now, if you would like a more detailed review of the Incoterm, you'd need to sign up for one of the training sessions held by the Institute of Export. That's it. Thank you for joining, and I hope you've learned something about the Incoterms 2020, and please do sign up for one of the training sessions.
Thank you, Corinne and Charles, for the presentations and advice there. I hope everyone's found that useful. We're now going to open the floor for a couple of questions. Please remember you can ask questions at any point using the question box on the control panel to the right-hand side of your screen. The first one I think I'll put to Corinne, and it's actually just picking up on one of your last slides. Someone from JAG International is asking just a bit more explanation on the meaning of DPU and kind of how you can use that particular term. Corinne.
DPU, in essence, DPU has the exact meaning as at DAPT, and all it is stressing is that instead of having to deliver the goods to a terminal, you can deliver it to any place that's unloaded. So in essence, DAT and DPU have the exact meaning.
Great, thank you. And a question I think which would probably be better for Charles. It's one which may help to kind of recap a bit of your presentation. It's from Ryan, and he asks kind of what are the main benefits of adopting Incoterms 2020, or what are the main benefits of the new rule changes? Charles.
I think the main benefit is that they're easier to use and hopefully easier to understand. Particularly, reference has already been made to the horizontal version of the rules. When we trade, I mean, if we think of the the very helpful slides which Corinne ended with, where she compared ex-works with DDP, Corinne rightly said there are risks with either. So obviously, from a buyer's point of view, ex-works is going to be cheaper than DDP because the delivery and the risk happens very much earlier in ex-works. So that must mean that from a buyer's point of view, from a customer's point of view, it's much cheaper and therefore better. But you also need to understand that there may well be things which are up to you to organize, like export clearance, like, for example, actually loading the goods onto your vehicle in ex-works, which you may or may not be able to organize physically on the ground. So whenever one looks at Incoterms, I'm frequently asked, which one should I use? To which I give the irritating lawyer's answer, it depends. What does it depend on? It depends on your factual situation, which you find yourself in. What access do you have to the other guy's warehouse? How familiar are you with export or import clearance. These are all things which need to be balanced. Now, coming back to your question, if you ask me what is the most useful change, I do think that the horizontal presentation of the rules is, as Corinne very kindly said, very, very useful. Because if, for example, you've been caught out in a previous transaction with a problem which arose because of your misunderstanding of risk, or if you got caught out because you didn't realize by using a particular Incoterm that export clearance was for you. So this time round, you're particularly obsessed about finding out who's going to fix loading or unloading, who's going to fix export clearance or import clearance. Now you can go directly to all 11 rules, all 11 Incoterms rules, under the heading of export clearance or under the heading of import clearance. So I think that's the most important presentational change. The most important substantive change, I think, or at any rate the most controversial one, is very case specific, and that is this idea of ocean bills of lading in FCA, which I have to say was very controversial, but we created it not out of the blue, but because FCA traders were telling us that banks were causing difficulties for them by insisting on ocean bills. So I hope that we've at least solved that one. The other main substantive difference is that when you sell containers under CIP, your default position is that the seller must insure to the higher all risks level rather than the lower C clauses level. I should add there that that change does not mean that the parties can't agree otherwise. It's perfectly possible for a particular seller and a particular buyer in CIP to agree on a lower level of insurance, just as it's always been possible in CIF for the parties to agree on a higher level of insurance. So in sum, what has ICC provided for the international trading community in 2020? Answer, I think, an easier to use set of rules, and also a set of rules which respond to particular needs which have become apparent in the 10 years intervening between 2010 and 2020.
Thank you, Charles. We've had quite a few questions come in the last minute or two. We won't be able to get to all of them because we do have a time limit here. A couple of people have asked about where you can find the book. There is information about that on the ICC website and also the Institute of Export website as well. We can circulate links to those afterwards. We had a question in for Corinne from Linda, who's asked, do Incoterms have any relevance to international B2C contracts? Corinne.
Business to consumers. Incoterms, you can actually use them. When we say B2C contracts, what are you referring to?
I imagine that's business to consumer. I'll give Linda a chance to follow up. I imagine that's business to consumer, yeah.
But Incoterms can be used internationally as well as domestic. So you can use Incoterms when you're moving goods, but they do not apply to technology that's maybe sent electronically, or they do not apply to financial transactions. But you can use, as I said, Incoterms for domestic delivery of goods as well as international. But then you have to find the most appropriate Incoterm for your movement.
If I can just add something to that, Corinne. Absolutely right. Incoterms applies to the sale of goods. That's the first point to make, not to the sale of services or financial instruments. We're talking here about contracts for the sale of goods. Second point, which Corinne made, absolutely agree with it. They are not restricted to the sale of goods across international boundaries. They can be used in domestic sales, where both the seller and the buyer are in the same country and where delivery and destination are in the same country. Obviously, certain parts of Incoterms will be irrelevant. So, for example, the rules on export and import licenses, if someone uses a CIP Incoterm for a sale of equipment from Manchester to London, then there is going to be no export or import licenses. So obviously you'd have to read out, as it were, parts of the rule which are irrelevant. But the question which was asked is, can they be used in B2C contracts? And I think my answer would be that they can. Traditionally, they've always been geared towards B2B contracts, but there is absolutely nothing to stop you from incorporating Incoterms in a sale contract between a business and a consumer. What my caveat to that would be consumer beware, because if you're a consumer, then the likelihood is that you will not be as familiar as your counterparty, your counter business party is likely to be with Incoterms, and you might find some surprises there simply because you're not a business. But the straight answer to the question, can they be used in a B2C sale contract, is yes, but consumer beware.
Great, thank you. Thank you both, Charles and Corinne. And I think in there as well, you answered a couple of questions we've had from service and kind of software companies as well. So that's been very useful. We are running out of time now. I do appreciate lots of people have sent in questions, but you can either email the admin@opentoexport.com address, or we can refer you to the technical helpline at the IOE afterwards, or you can sign up for training with the IOE as well. So yeah, do get in touch if we didn't get to your question, and we can show you the right direction from there on. But yeah, thank you so much to Charles and Corinne for the presentations and advice there. I hope that's been useful. And yeah, I think we're going to start wrapping up now, so we can move on to the next slide, please. So in terms of what the Institute of Export and International Trade are up to at the moment, we are running several Brexit-related training courses, many of which are fundable by government grants. I'm sure you won't need reminding of the enormity of what is ahead, but you really do need to ensure you've got core export skills covered, including completing customs declarations. So please do have a look at the funding available and for training courses on our website. And if your interest has been piqued and you'd like to learn more about Incoterms 2020, we are running a series of training courses licensed by the ICC this autumn to help you stay up to date. And finally, we have our last World Trade Summit of the year coming up on November 28th. This is a great chance to hear from global trade experts and to network with fellow exporters in your region. In this case, it's the West Midlands in Birmingham. You can find details about all of our training courses, our events, and our membership offerings, and our education programme at export.org.uk. Next slide, please. In terms of Open to Export, our next webinar will look at how exporters can reach international customers online using Amazon. That is taking place on November the 14th, and you can find details on how to sign up to that at opentoexport.com/webinars. And here you will also find a recording of today's webinar, which will be put up hopefully later on today. Next, please. Finally, we're currently running an Open to Export action plan competition with Bibby Financial Services this autumn. This is a fantastic opportunity for SMEs to win £3,000 towards their export plans, and completing an export plan is also a great task to be doing at the moment, particularly with so much opportunity but uncertainty ahead. Planning is really very key. The deadline to enter is November the 5th, ahead of a showcase final at the aforementioned Birmingham World Trade Summit on November 28th. If you are an SME, I really would consider looking at that. You've got a great chance of reaching the final at least, and all finalists will win free membership with the IOE, so that's definitely a great opportunity there. But that's all for today. We hope you found that useful, and if you have any concerns or questions, please do get in touch. But I hope you have a great rest of the day and a great weekend as well. Thank you, everyone. Goodbye.